Well, hello, everyone. We will go ahead and get started. It's just after 3 o'clock our time. My name is Carvel Taylor, and I am a trust officer here at BECU Trust Services. Welcome to estate planning for the LGBTQ plus community, hosted by my department, BECU Trust Services, presentation done by attorney at law, Kate Jones. Happy Pride Month, everyone, and thank you all for joining us this afternoon. We are so excited to kick off Seattle Pride Weekend with this very informative webinar. Just a few housekeeping items. This presentation will be recorded and available on the becu.org website within 1 to 2 weeks. So if you miss anything or need a refresher, you'll have that option to go and listen to playback. We're going to cover a lot, so you may end up using that. Please use the chat box feature for all questions. We will have Q&A at the end of the presentation. So if we miss your question or you think of something after the fact, we will follow up with you individually. We will also provide our contact information at the end of the presentation. Today's presenter is the esteemed attorney at law, Kate Jones. Kate Jones has been practicing estate planning for over 10 years and started her career at Seattle University School of Law. The law offices of Kate Jones is a husband and wife operation, and Luke, Kate's husband, joined the practice as office manager and CFO back in 2018. The law offices of Kate Jones has 2 locations locally, one here in the West Seattle area and the other in the Tacoma area. So she is serving the greater Puget Sound area. Before I hand it off to Kate, I'd like to go over our agenda. Today, we'll be covering the most common documents needed for estate planning and preparation for disability, incapacity, and end of life, who needs a will, basic introduction to probate and community property laws, unique concerns for the LGBTQ plus community, such as blended families, adopted children, and unmarried couples' rights. This presentation is very near and dear to my heart as I am actually a part of the LGBTQ plus community, and it is really important that we get this message out there. Estate planning is important for everyone, especially the LGBTQ plus community. So it's with great honor that I kick it off to Kate Jones, who will be leading us through the presentation. Kate, are you there?
I am, yes.
Awesome. Thank you so much. I'm going to hand the baton over to you.
Okay, great. Thanks so much for that great introduction there. So I'm just going to start talking a little bit about the most common estate planning documents that are necessary in general for all individuals. So the first one is one that most of you have probably heard extensively about. That's your last will and testament. That's a document that allows you to detail what your wishes for your property would be after your passing. It's a document that you sign and create while you are living, but it is editable at any time. So it's actually fairly common for most people to update their will several times throughout their life as their circumstances change. It's a good document to make sure you keep in your possession so that you are able to review it. I typically recommend every 5 to 10 years, making sure that it's still accurate and up to date. And then it also designates an individual that you would trust to serve as your executor. That is the person who's going to be in charge of locating your original will document. So very important to make sure that that person knows where the original will is located, especially if you have it stored in some sort of locked safe area. You want to make sure that they know how to access that, so they're not searching for your will after your passing. That executor will take your original will document and file it in the probate court, depending on what county you reside in at the time of your passing. And they're in charge of basically settling your estate as you have detailed in your will. So transferring title to assets, paying final debts, basically wrapping up your estate for you after your passing. Also, that will has the opportunity to name individuals that you would trust to care for your minor children if you had any children under 18 at the time of your passing. It also can set up a contingent trust for the benefit of minor children if they are under a certain age that you would want to specify that their assets should be managed on their behalf until. My job when meeting with my clients and creating their will document for them is to provide them all the possible scenarios that could potentially come up in the future that you might not have thought about. And I try to include as many alternate scenarios in the will as possible. So another important document to talk about is a power of attorney document. So there's two kinds of power of attorney for finances and then power of attorney for healthcare. That designates an individual that you would trust to make your decisions about your finances and healthcare if you were determined to be disabled. So a durable power of attorney for finances and healthcare means that the document outlives a diagnosis of disability. And then you have the option to make your power of attorney a springing power of attorney document, which means that it doesn't actually become active until certain conditions are met, which is usually disability or incapacity. It's also very important for spouses or couples to have power of attorney documents so that they can name an alternate who they would trust to have access to their financial decisions if their spouse and they both were disabled or if one predeceased the other. So this is very important. Power of attorney is a pretty broad power. You want to make sure that the person you're designating is someone you fully trust, someone you are okay with having access to your bank accounts and that you know won't abuse that power. So it's definitely a pretty strong power of appointment. And you want to make sure that you fully consider all of the things that that person will be able to do on your behalf. Another document that I typically handle are healthcare directives. So that's a document that states if you're determined to be permanently unconscious, if you would or would not want to be removed from life support. You can designate certain conditions that must be met in order to be removed from life support. And typically it specifies that you would want 2 physicians to determine that you are permanently unconscious before life support is removed. This is a document that directs your power of attorney for healthcare in the decisions that you would want made on your behalf when you're unable to voice them yourself. And then a document, another one that's not on here, but I'll quickly touch on, is a disposition of remains. So in the early 90s, Washington State allowed individuals to designate what they would want to happen for their remains after their passing. It's a document that specifies if you would want to be cremated, buried, and any other options, and then it also allows you to make specific requests for things you would or would not want for your services or funeral. So that's an important document if you don't necessarily have the same belief system as your family, or if there's certain things that you've seen happen in the past that you really do or don't want for yourself or for your spouse. So if you don't designate that, that means that your next of kin is the first to make those decisions on your behalf. So that would be spouse first and then any lineal heirs after that. So this is just a couple of examples of when it's particularly important to have estate planning. So as I mentioned, any individual over 18 can create a will document and most likely should if they want control over what would happen to their property or control over what might pass to their heirs after their passing. So these are just a couple of examples of when it's particularly important. So if you have purchased or own real estate, or if you have minor children, that's going to be the 2 most common circumstances. Like I mentioned, the will gives you flexibility for providing for your minor children, as well as naming individuals who you would want to care for them on their behalf. And then a couple of other important times that comes up is when you don't want your property to pass according to Washington State probate. So if you pass away without a will, that means you passed away intestate. And there are certain intestate laws that come into play if you don't have a will that specifies your wishes. So Washington has a set of fail-safe rules for probate. And that means that if you pass away with no spouse or lineal heirs, that your property would pass up to your parents and then down to your parents' heirs. So brothers and sisters, nieces and nephews. This graph here is just a good visual for how lineal heirs actually look and how the property would pass up to the previous generation and then down from there. So it's very important to have a will if you wouldn't want your property to pass as this table shows. So typically when I'm creating will documents for my clients, it's very common for people to name their spouse and then their children as their heirs. And I always recommend including a third preference of how your property would pass if you wouldn't want your parents to inherit and be in charge of distributing your property after your passing. So if you wanted it to go directly to the benefits of nieces or nephews, or if you had friends that you wanted to include, or if you are unmarried and want to make sure that you provide for your partner or significant other. All right, so some common misconceptions about estate planning is that the probate process is particularly scary. Luckily, Washington is not as complicated as some other states tend to be, and so it's not necessarily as big of a deal to avoid probate. This is the #1 inquiry that I get on my website and from potential clients is how to be sure to avoid probate. So some common misconceptions are that probate is expensive and untimely. This is not the case in Washington state. If you have a validly executed will with a self-proving affidavit, so that means that you had the will properly signed before 2 witnesses and a notary was present to notarize an affidavit, then your executor just takes your will, files it with the probate court, pays a $250 fee, and that is all the court interaction that they actually have with the executor. So probate is not scary here if you actually already have a valid will in place. Your executor has a 4-month period where they have to publish notice in order for creditors to make a claim against your estate. And then after that, they're able to just distribute your property as you've designated in the will. So it's really not, there's no judge or magistrate that's overseeing the process. No one is reviewing what the executor is doing. There's no check-in, there's no timeline. It's really just on, it's the responsibility of the person that you've named as your executor to be sure to follow through and get that probate process done as quickly as possible. So another common misconception, as I just talked about pretty extensively, is that creating a will actually avoids probate. This is not true. It just means that it streamlines probate and designates an actual individual to be in charge of carrying out your wishes and your documents. So also a lot of misconceptions that people think if they create a living trust in order to avoid probate, that also means that they will avoid inheritance taxes. So in Washington state, if your estate is valued over $2.3 million, there is a sliding scale similar to income that the state takes a percentage of the amount over that $2.3 million amount. And then the federal government has a $5 million number where they will also take a significant chunk out of any sort of inheritance that passes to heirs. So the will itself doesn't actually avoid probate, and avoiding probate does not avoid inheritance taxes. It just gives you a little bit more flexibility in planning. So if you and your spouse have a valid living trust, that means that when the first spouse passes away, it can actually carry over the second spouse's $2.3 million credit so that the entire estate is valued at 4.6, and that first $4.6 million amount is not taxed by Washington state. So every person does not need a revocable living trust. If you do not have over $2 million in assets, I very rarely recommend going through the process of creating a living trust. So until you reach that actual point that you're going to be trying to do some more complicated estate planning, there's really no need to create anything beyond a basic will and the other types of estate planning documents I mentioned 2 slides ago. And then last common misconception is that all types of properties are subject to probate. This is also not true. So any type of account that you have with a company is actually not subject to probate if you designate an individual to inherit that account. So bank accounts, investment accounts, life insurance policies, retirement benefits, anything that you are actually working with a company that you have that account with, you can name what's called a pay on death beneficiary directly on the account, and that avoids the account from having to go through probate. So that named individual just has to have a valid death certificate for you in order to access and close the account as is appropriate at the time. So if you are above that $2 million mark, there are a couple of estate planning tools to avoid probate. So the first is to acquire property in joint tenancy. That means that you and other individuals equally own a piece of property, and it will automatically pass to the co-owning individual upon another individual's passing. And then, as I talked about already a bit, the revocable living trust. So that is most important if you are married and have over $2.3 million in assets, because as I mentioned, it keeps the first deceased spouse's credit for the second spouse's passing. So also revocable living trust gives you quite a bit more privacy. Probate is public record. So if you are specifically wanting to avoid being searchable in the court system, that is also living trust is a good option for you. And then if you also want to have a bit more control and longevity over your control over your assets, then a revocable living trust is going to be a good option for you. Once you will property to someone in your last will and testament, so once you gift it to them after your passing, it is now their property to make decisions with what they will for it. So the living trust actually holds the property in the trust's name rather than the individual's name, and there is an individual appointed as trustee to oversee what is happening with the trust. And then another important time that a revocable living trust might be important is if you have any sort of special needs individual that you're wanting to leave property to. The next option that you might have is a credit shelter or marital trust. So that's going to be a lot more complicated type of estate planning. That's more for Medicaid planning and being sure that your property is held so that your surviving spouse inherits your property wholly and it doesn't end up getting used for your Medicaid. I'm not going to cover a whole lot of that. That's a very complicated estate planning tool, and that is definitely something that you would want to speak with an attorney if you're wanting to find out if that's the best for your needs. Another option that's not complicated is a transfer on death deed. So that is if you're wanting to pass real estate outside of probate without using a will document. So it's actually a deed that you execute while you are still living and file with the county where the property is located so that the individual does not have to go through the probate process in order to transfer the title to the property after your passing. So again, it's filed with the county and the individual just has to have a valid death certificate in order to change the title to the real estate into their name. Another option is a gift or a quitclaim deed. This goes along a lot with that more complicated Medicaid planning. The only thing with this is that if you do complete a gift or quitclaim deed, it is irrevocable, which means that you can't change your mind later. So this can be oftentimes a big roadblock for a lot of elderly clients. They want to gift their property to their children, but the problem is that you don't retain any kind of ownership or decision-making rights. So if something happens, you have a disagreement with your child or whoever it is that you've gifted the property to, you don't actually have any ownership rights any longer. So they can fully remove you from the property as if you were no longer an owner because you're no longer on the title. So that is also a pretty complicated, difficult process. And so I'm just going to generally cover it. It's a good idea to, again, speak with an attorney if that's something that you think best fits your needs. And then the last tool here are community property agreements. So that is a contractual agreement between married spouses about your expectations for your passing of your property after your death. So Washington is a community property state. That means that everything acquired between married couples during the marriage is considered equally both spouses. A community property agreement is important when you have lots of separate accounts. So if you have separate bank accounts, if you have life insurance policies, if you have retirement benefits, those are important to have that CPA in place so that if your spouse survives you, they do not have to go through the probate process in order to close those accounts. So those types of accounts are held by corporations all over the country. They may not be a Washington state corporation, and so they might not be running by Washington state laws. And sometimes they do require letters testamentary in order to close that account. So that is what you receive when you have a valid will and file probate. The executor is given letters testamentary in order to be able to close all the accounts, group all of the assets together, and distribute them as is specified in the will. So the community property agreement avoids that process for any surviving spouse. So if it is a Washington state company, they already know that community property is the rule, but it does help streamline the process for the surviving spouse so that they are not struggling through the probate process after their spouse has passed away. So it just makes everything a little bit easier on the surviving spouse if the time comes. So a little bit more about what is considered community property. So that also includes all wages earned by both spouses during the marriage. And it also includes interest income. Even if you have those separate retirement accounts and separate investment accounts, any interest income earned during the marriage period is still community property. So it can still be claimed by your spouse in a divorce proceeding or after your passing. So a couple of things that aren't community property. So if you're married and you inherit property, or if you are gift deeded property and it's only in your name, that will keep it separate property and it does not go into the community assets. And then also any separate property held before the marriage by either spouse. So that this is where things get a little bit tricky. If you use community funds in order to maintain those properties, then it will still be pulled into that community property rule. So even if you have a property held only in your name, say you inherit a rental property from your parents, if you're maintaining that rental property solely from the income you're making from the rent on that property, then that is going to keep it separate. But if you start commingling your wages or anything that, any monies that would come from joint accounts, as soon as you start using that joint money, that property, the whole thing is automatically community property. So the state doesn't want to spend time digging through accounts and making sure that things are fully separate. You want to make sure you go in with clean hands if you are wanting to keep things separate. And the best way to do that is with a prenuptial or postnuptial agreement. So if you are very concerned about an inheritance that you receive and making sure that it is considered separate property, you'll want to acquire a postnuptial agreement, which is a contractual agreement acquired after marriage, specifying what is each spouse's individual property and then what you both consider community property. And that is a little bit more complicated, not quite estate planning. It's going to be more family law oriented. So if you think that that's something that you need, it's definitely a good idea to consult with an attorney. All right. And then just talking a little bit about what's most important for estate planning for blended families. So talking about second marriages, if you have children with another spouse previously or another significant other, if both spouses have not fully adopted the child, this is when times are going to be important to especially make sure you have your estate planning hammered out. So the first one is mirror last will and testaments. So that means that you both create your wills and that they both say the same thing. so that all property goes to each other first, and then how the property should be divided after both spouses passing. Another way to do it is to leave your spouse a 50% interest, so that's the statutory requirement for community property, and then you can designate your 50% portion for where you would want that to go after. A couple problems that can be created by that are if you are designating heirs for your primary home. So if you designate that 50% of your home should go to your significant other and 50% of your home should be distributed elsewise, you might actually be forcing your surviving spouse out of that home at the time that you pass away. So if they can't come up with the money, or if they can't agree with the other person that you've named to inherit that property, they might eventually have to sell in order to pay the other 50% off. So that's a tough one if the two of you don't fully agree, especially if you name your spouse first to inherit everything, and then you agree on an alternate scenario afterward. As I mentioned at the beginning, wills are always changeable and always revocable. So if you pass away and your property passes wholly to your significant other, there's no enforcing the alternate scenario in your will later. So the second remaining spouse could always change their will and change where the marital assets are going to be distributed if one spouse were to pass away significantly before the other. And of course, if the second spouse lives long enough to spend all of that money and use all of the assets, there might not be anything left afterward. So a good way to avoid that problem is by utilizing those non-probate assets. So directing a beneficiary on the account itself. And again, that was bank accounts, savings accounts, life insurance, and retirement accounts. So you can actually avoid the will problem, much of the will problem, by designating an alternate inheritor on the accounts itself. So taking out a life insurance policy or naming percentages on a retirement account for if you wanted to leave your spouse some money and other heirs other money. Another really good tool is that transfer on death deed coming back around. So if you want to designate a different individual besides your spouse and you have separate property, or if you are unmarried and you want to designate that a different individual should inherit the property after your passing, you can execute that transfer on death deed and file it with the county so that it passes automatically upon your death. So then very briefly, since I've already talked a little bit about both of these, you can also go through a more complicated process of creating a trust. And remember, not everyone needs a trust, but a qualified terminable interest property trust is a much more complicated estate planning process, which actually puts all of your property into the trust name and allows the first deceased spouse to give a life estate in the property to their surviving spouse without incurring federal gift tax. So that means that the surviving spouse is entitled to the income from the trust while they are living, but then upon their passing, the trust assets actually pass to someone else. So that is if you have a large estate and maybe several children from a previous marriage, and you want to be sure that your children are provided for, but you don't want to cut your spouse out entirely. You still want to make sure that they're cared for the rest of their life, and you want to make sure that they can claim the income from the property. That's also going to be really important if you're involved in any kind of family business, and you want to make sure that the business and the property the business owns pass to your family members. But again, you want to make sure your spouse has that income interest, but not power of appointment over the actual principal of the trust. So the property itself and anything above and beyond the income that is designated for the surviving spouse. And then I talked a little bit already about revocable living trusts. It is a more expensive estate planning tool that actually changes the title of the property. So accounts, real estate, any type of property that you can think of actually changes the title into the name of the trust. So it's no longer the individual's property, which is how it stays out of the probate process. And it just is it's harder to put together, and it's definitely a lot harder to take apart. So it's always revocable or editable. You name an individual who's in charge of overseeing how the assets should be distributed in the future, and you're naming beneficiaries that the trustee has the decision-making power to gift that property out of the trust, to close the trust, or just to maintain the trust and distribute the income to the beneficiaries. So both of those are a bit more complicated, and you would definitely want to make sure to consult with an attorney if you think that either of those are important for your situation. So then last topic here is estate planning tools for unmarried couples. So if for some reason you're not wanting to get married, which is a totally valid choice, there are a couple ways that you can acquire property together and make sure that your significant other still inherits that property. So first and foremost, making sure you have a last will and testament detailing your wishes for your property, making sure it's valid, making sure you have an attorney help you do it so there's no question later from any other sources, any other heirs, any other family members who could come back and challenge the validity of the will. So we don't want that. We don't want estate disputes or challenges later. We want to make sure the will is ironclad, that it was done correctly, and there's going to be no question about that in the future after you're gone and unable to defend it. Another way is that joint tenancy. So again, if you acquire property jointly, it automatically passes to the co-owning individual. The transfer on death deed, so that's the automatic transfer of the deed, and you create and file that document while you're still living. And then, of course, the revocable living trust, which is going to give you a lot more control over what happens to your property for a longer period of time. Because as we talked about, if you transfer property in a will, that becomes that individual's property. They have no legal obligation to transfer that property in any other way that you haven't specified in your will. Another couple of really important things for unmarried couples. So if you are married and you are disabled, your spouse is going to be the automatic choice for your healthcare powers. So it's really important to make sure you have a durable power of attorney for healthcare, naming your significant other as your first choice to make those decisions on your behalf. Also, a really important form for LGBTQ couples is a hospital visitation form. That's a document that is witnessed and notarized and is actually names the significant other as your first choice to be able to come in to the hospital, visit you, and of course, help assist in your health care. So if you don't have the hospital visitation form and you don't have the durable power of attorney for health care, significant others really don't have any legal right to enter the hospital to visit you and to claim that they are your family members. That's usually your immediate lineal heirs, so children or parents, and they would have the right to exclude that individual from the process if they didn't have that legal documentation. And then also, of course, ensuring your significant other has financial powers, so that springing power of attorney for finances, so naming your significant other as your power of attorney for finances if you're disabled. So that's only if you're unable to make your own financial decisions for yourself, actually opens up all of your accounts for your power of attorney to make those decisions on your behalf. Another way to make sure your significant other has all-inclusive financial powers is to name your significant other as executor and give them non-intervention powers. So that means that the court is not overseeing what they're doing on your behalf after the filing of the will. So they would be ultimately making all of your decisions on your behalf and following your general wishes as named in the will document. And then, of course, if you have bank accounts and that you are both named as joint owners on those accounts, each significant other has equal access to the whole of that account. So if you want to make sure that your bills can be paid, you can create a communal fund, a communal account, and just make sure that both of you are named as owners on that account. So that is all that I have for today. Because if
Awesome.
I don't see
Thank you so much, Kate.
Of
Yeah,
course.
so now it's time for Q&A. So there's two ways to ask questions. You can either use the chat option in the GoToWebinar and you can type in a question, or you can unmute yourself and ask a question. So we've got some time now, so let's get some questions rolling in. So Kate, while we're waiting for questions, I'll ask a question. So me and my spouse got married in 2017. So prior to us being married, if I didn't have him on a, say, joint on some of my accounts or actually have a will, would he be entitled to any of my assets if we weren't married?
So no, not unless you held those accounts jointly. So then of course it would automatically pass to your spouse. But but no, significant others don't really have any legal rights until you actually cross that threshold into marriage or have your estate planning documents put together.
Thank you.
Yeah, of course. I know we have one more slide here. I'm not sure if you want
Oh
me
yeah, well, no, that's okay. We'll get to that when we're wrapping up here. It looks like uh, Debbie may have a question. I don't know if she can unmute herself or not. Let's see here.
Can you hear me?
Yes, we can hear you. Hi, Debbie.
Hi there. I'm curious because of, I'm legally married to my spouse through gay marriage rights, and there is some concern with everything that's going on about things being revoked. Should I have some of this stuff in place as if we weren't to protect ourselves? I mean, what is your recommendation where that is concerned?
Yeah, that is a great question. And that is definitely a number one concern for a lot of the clients that I assist. So I would recommend yes, especially if you're planning on traveling to places that are known to be hostile. Then you want to make sure that you have that power of attorney document and you have that that hospital visitation form. So yeah, you would definitely want to make sure that you have those ironclad documents already in place, since those are a full recognition of what your wishes would be, rather than having any state laws or family members being able to come in and challenge that later. So that is usually what I do with my clients as I move forward, as if that did actually happen, although I very much hope that it doesn't. And then again, make sure that you have those documents in place and that you travel with them if you're planning on going anywhere that you might have that concern.
Thank you, Kate. And so our next question comes from Elizabeth Emmerich. Go ahead and unmute yourself, Elizabeth. Elizabeth, we can't hear you if you're speaking. I've unmuted you, so if you want to go ahead and unmute yourself, please.
Oh, sorry. I just was having a question about the probate process. I understand that when there is no will, the estate goes into the probate process, but it sounds like if there is a will, the will still can go in through the probate process. So it's just wondering if you could go over one more time what triggers the probate process. What's the scenario where a will does go into probate versus what is the scenario when a will does not go into probate?
Okay, great. Thank you. That's an awesome question. So there is no scenario that a will does not go through probate. So if you have a valid will, it streamlines the probate process. It means that your executor takes that document and is granted letters testamentary to be able to transfer the title to your assets and close your estate on your behalf. The only way to avoid probate is those couple of tools that I mentioned, and I'll go back to that slide real quick. So there's a couple of ways to avoid probate. It's on the right here, and that is creating those transfer on death deeds, creating a living trust, or acquiring property in joint tenancy with the right of survivorship. So if you are both joint tenants with the right of survivorship, that means that the property automatically passes to the co-owning individual. But that is a really common misconception that creating a will actually avoids the probate process, and that is not true. The only time that if you have a will that you wouldn't go through the probate process is if your estate was valued at less than $100,000 and you're still going through probate. It's just a different process. It's called a small estate affidavit. So it's still through the probate court. It's just less expensive and less timely. The probate process is hard to avoid because the probate process actually gives notice to creditors after your passing. And the state it's not in the state's best interest to have individuals avoiding credit after their passing. So it's a lot more difficult to avoid probate without going through the living trust route. Did that answer your question? Okay.
Thank you, Elizabeth. Great question. Our next question comes from T. Rafa. I went ahead and unmuted you. If you could unmute yourself, please. We still can't hear you, so you still may be muted. All right, well, we're waiting for T. Rafa to join. We have another question coming in from Linda Davenport. Linda, I've unmuted you. If you could unmute yourself, please.
Yeah, thank you. Can you hear me?
Absolutely.
Yeah.
Okay. Yeah, so Kate, can you go over, some of the things that I've experienced with my mom and her estate planning documents is basically, she has a will, but then she's, putting, and she wants her assets divided among 3 adult children equally. But then she goes and connects with her financial institution and they start talking about putting beneficiaries down on her different accounts. And so I feel like it contradicts the will or can contradict the will. Can you talk about that a little bit?
Sure, yeah. So that's a great question. And yes, it can officially contradict a will. So wills should not include mention of non-probate assets. So that is bank accounts, life insurance policies, retirement accounts, and investment accounts. Those are all considered non-probate assets. And so the will doesn't actually have governing power over those types of assets. They should have a pay on death beneficiary named on the account for how she would want the assets in that account specifically to pass. Every will should also include what's called a remainder clause. That is if you were to purchase or inherit property in the future, or if you had those non-probate assets and they did not have a valid beneficiary named, then it would actually pass through the remainder clause of the will. And so she should, of course, make sure the remainder clause would cover any of those types of circumstances. This is always a big hang up for every client that I have because they're like, I'm not going to inherit property in the future. I don't want to include that. But the remainder clause is really important because it could ultimately be a big chunk of the estate that gets pulled into the remainder clause. So it is best to name beneficiaries directly on the account. That keeps them out of the probate process and makes them pass automatically when the individual passes away. So then the named beneficiaries only have to have that valid death certificate in order to close that account and claim their beneficiary designation. So what she should do to avoid any type of conflict is she can just go ahead and name all 3 adult children as beneficiaries on the account. It doesn't have to just be one individual. Or like I mentioned, she could avoid naming beneficiaries at all, but then that would actually freeze that account during that 4-month period where creditors have a right to bring a claim against the estate during the probate process.
Thank you, Kate. And let's see, we've got another question coming in from Deborah Wiggy. Go ahead and unmute yourself. I've unmuted you.
Oh, sorry. For some reason, it wouldn't unmute. Can you hear me now?
Yes, we can.
Okay. Similar question. My parents are getting older. My dad has dementia, and so he's starting to show signs of that. This is kind of a BECU question as well as he's the main member on the account. Should we have her open an account in her name and transfer all of the things to her name? And is there something special that I should pass on to her when it comes? And that's probably a big loaded question. I should probably talk offline.
So
Just
Deborah,
kind of curious.
I could chat with you about the situation for your parents specifically offline. But Kate, if you want to answer it generally.
Sure. So best to have both spouses named on the account for most circumstances is my general answer to that question. Of course, without knowing more details, it's a little bit harder for me to say specifically. But holding the account as joint tenants, so both being joint account owners, would mean that the property in that account would automatically pass to her upon his passing. Also a good idea to speak with an estate planning attorney and make sure that they have their estate planning documents in place. So the actual threshold to create a will is pretty low. The capacity threshold, so all you have to know is the heirs of your body, what property you own, and who you want it to go to. So that's the estate planning attorney's job to evaluate his competency to determine if he would be able to create other estate planning documents. But that's why these types of documents are so important to plan ahead of time, because of course everyone's going to meet that limit, right, where they no longer have capacity. My partner and I joke all the time, it's estate planning, not estate emergency. So it's definitely a really good idea to maybe make sure that they have their estate planning in order, and if not, to get some help as soon as possible.
Thank you.
Thank you.
Of course.
And our next question again is from T. Rafa. I've unmuted you. It looks like I see you on twice, so hopefully we've got the right one here.
Hi, can you hear me?
There we go.
We can.
Yes.
Okay.
Thank you.
Yeah, sorry, I had to switch to my phone because I don't have a microphone on the computer. Yes, I have a question about, I was with a partner for approximately 20 years, and we had a son who is now 35. At that time, I wasn't able to be on the birth certificate, and we never married. This was all before all that stuff. We have split up. There's never been an issue with him being my son. Now, will there be, but because I've never adopted him or anything, is he legally, like if I have named him my durable power of attorney, health, and all of that stuff as my son, is there something I should do about that, or is that legal that he's my son?
So it's not technically legal that he's your son unless you went through the adoption process.
Right.
However, you already have the document that I was going to recommend making sure you had, which is that power of attorney document. So that would give him the right to make your financial and healthcare decisions if you're determined to be disabled. However, he is not your legal heir. So if you would want your property to pass to him after you're passing away, then it's important to make sure you get a will document created.
Okay, I have done that. I don't know if this is your purview or not, but when I had to sign up for Social Security, they ask if you have any children, and I really didn't know what to put because he kind of is, but he isn't. Do you know anything about that?
So that's a tough question without me knowing a lot more details about
Okay.
your Social Security. A lot of times, if you personally recognize that individual as your child, I would go ahead and make sure anywhere that question is asked that he's included.
Okay. Okay.
So there's a question later that you fully considered him your child, even if he's not your biological child, and even if you didn't formally go through the adoption process.
Okay, super. Thank you.
Of course.
Thank you, everyone. Are there any other questions before we wrap up? All right, Kate, if you could go to the last couple of slides and we will wrap this up. If you can go to the slide before, please.
Oh, sorry.
Thank you. All right, everyone. Well, thanks again for joining us. As a reminder, this webinar was recorded and it'll be available at becu.org in about 1 to 2 weeks. So if you want to listen to it again, you can go back and do that. If you have questions or actually want to have some estate planning documents drafted, you can reach out to Kate Jones directly. Here's her information, of course, here in front of you. You can jot that down. Once the webinar is posted, this presentation will also be viewable online as well. So you'll be able to reference this later if you need to. So if you're in the market of drafting an estate plan, whether it's a will, trust, powers of attorney, anything like that, you can reach out to Kate and she can help do that if you decide to. And last slide is, of course, us, BECU Trust Services, who is hosting this webinar. So you can reach out to us also with any questions around your estate plan, specifically to around administration. So if you're thinking about drafting a plan, whether it includes a will or a trust, and you want to name a corporate fiduciary such as us to act in a fiduciary capacity, whether it's trustee, co-trustee, successor trustee in a trust document, or the executor or personal representative in your will. We would be happy to have conversations around that as well. As you can see on the screen too, this is our direct contact information for my department. You can give us a call, you can send us an email, and we would be happy to connect. Other than that, thank you again for joining, everyone. We really appreciate your time. This was very informative. Thank you, Kate, for your time. And I will bid everyone a happy weekend, happy Pride weekend if you're celebrating here in Seattle. And this concludes our webinar. Thank you so much.